Hello friends. Today we're going to discuss about Digital Personal Data Protection Act 2023. What are the implications on healthcare industry in India? I'm Dr. Suresh Padadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be introducing various concepts with regard to data. I'll also be discussing about the Digital Personal Data Protection Act 2023. What are the implications on the healthcare industry? What are the different challenges and how to overcome these challenges will be discussed in this video. The first question is, why should we regulate data? The data means transparency. Why should we regulate? Let's answer this question. First and the foremost, earlier, the gold was considered as an important currency. Later, the crude oil, that is the petroleum, became the currency. Of late, data is the present currency. Similar to the gold and oil, they are available in a crude format. They need to be assembled, organized, and processed for utilization. Any person who is able to have this crude data, process it, analyze it, and utilize it for the purpose, he can control the world. Why did I use this strong word that he can control the world? Every mobile phone across the world generates data. It can be passive data, which is collected without your knowledge, or the active data, which you produce by interacting in the internet, apps, or on social media. That means the both passive and active data, where you interact with the mobile phone, which has become an extension of your brain. That means it is able to capture your desires, your dreams, your wishes, your choices, your predictions, fantasies, orientations, preferences, impulses, your value system, beliefs, culture, your feelings, your behaviors, thought process, your network, your paying capacity, and so forth. If a person is able to get hold all of this data, he can control you by simple way of knowing your dreams and choices. He will put across to you what the brain wants to look into it, and he will give you a limited option of menus and choices. And invariably, over a period of time, without your knowledge, you will be dealing according to the data which you will be fed. That means he can, the person who owns the data, can not only manipulate your choice, at the same time, he can manipulate your voting capacity. That means the person can interfere in the democratic world by manipulating the election. That means data is very powerful nowadays. It can control your brain indirectly. The only way is how to get this data, how to process this, how to analyze this, and based upon that, how to put the menu in front of the people. On that basis, the person can control the world. This is how I can put across. What do you do in a whole day? It may be fitness data, your bank account, your smartphone app usage, also your social media account. What do you think? What is your interest? What do you watch? And sometimes you do like certain photographs by interacting with them and also interact with various people, your emotions, your desires, what you depict. That means the mobile phone and the people who are gathering data will be able to know about you without your knowledge. If they know about you, they can manipulate and control you. Now let's understand what are the different types of data. Here, the data earlier was in the physical format, that is, in the paper format. Over a period of time, this paper format is being coded into digital. Either the data is directly entered into the computer in a digital format, or else initially it is taken on the paper and later it is coded into the digital format. That means approximately 60 to 70% of the data is now digital across the world. In this again, the data, some of them is personal, which is identifiable, your own personal biometric, your wishes, your thinking, all those are personal. Some of them are non-personal data. Non-personal data is a best example would be the Google map. For example, if you're traveling on a road and you want to reach certain place, the indicator of the blue, red, or yellow, which clearly indicates how many people are also traveling in this road, and at the same time, how much time is required to reach that place. Here, the non personal data is utilized to predict within how many minutes you'll be able to reach. Here, the non personal data is taken. Of course, we believe it is non personal data. On the way, if you stop somewhere for a shopping, many a time it will be also be taken. Further, the critical data. The critical data are with regard to sovereignty of the country. It can be nuclear data, military data, defense, finance, which is very critical for a country is considered as critical data. Now, the data can be based upon the organizations which are inside the country. For example, there is a company which is invariably established in India and they are collecting the data. There may be organization which is outside the country. For example, a device which is manufactured in US or maybe in Germany, they are collecting the data. That means a mobile phone manufactured in US, a passive data is collected to know your activities, your preferences. Again, the data which is transferred from India by the way of selling certain goods or services, and that data also belongs to India as per the current legislation I'll be discussing shortly. Now, the implications in the healthcare industry between the doctor and the patients, there are many people are coming in between. For example, there are various medical devices. The devices can be medical instruments, non medical instruments like router, Wi Fi, modem, internet service provider, and also the various mobile phones. And many a time, this data is kept in the cloud. The insurance company, which is taking your data with regard to medical or health to reimburse, and they are also processing your data. As I mentioned, medical devices, electronic health record. The company who is dealing with EHR may also analyze your data. Many a time, the doctors are very busy. Hence, the data is transferred for the purpose of medical transcription, biomedical, pharmaceutical industry. What is the medicine sold commonly in this area? How much medicine is required? Who are the people who are consuming? And finally, the patient is paying through bank. And even the bank people will come to know what are the things the people are buying, where it is, the currency is spent. That means between the doctor and the patients, this an amazing relationship. There are too many actors are playing in between, and sensitive data can be hacked or utilized without the knowledge of either the patient and the doctor. All these people who are involved by chance or by the way of responsibility being in that industry to provide services, all play an important role. But at the same time, they also need to know that data privacy is very essential. Similarly, HIPAA Act was introduced in US. All these actors were brought under the legislation, and if there is any data leakage occurs, the person who is involved will be fined or will be imprisoned. Here, the data owner invariably considered as public, or else the person from whom the data generates. The data creator can be, especially in the health industry, invariably the doctors who are entering the signs and symptoms, lab investigations. The transmitters are those people who are internet service provider, and though they also have to come under the HIPAA compliance. Business associates, insurance companies, medical devices, and the service companies like subcontractor, like computer management, all those people are important to maintain the personal data security so that the privacy is maintained. And with regard to all these online security and physical security, if you understand the physical security at this point of time, keeping the health record in the physical format, and now we are putting every data of the patient online. That means the security has to be robust. Now let's understand what is e-health. World Health Organization defines e-health as a cost-effective and secure use of information and communication technologies in support of health and health-related fields, including healthcare services, health surveillance, health literature, health education, knowledge, and research. That means e-health is very huge. Anything which comes under the rubric of technology and health will become e-health. Similarly, if you look at the telemedicine, World Health Organization defines telemedicine as the delivery of healthcare services where distance is a critical factor by all healthcare professionals using information and communication technologies for the exchange of valid information for diagnosis, treatment, prevention of diseases and injuries, research and evaluation, and the continuing education of healthcare workers with the aim of advancing health of individuals and communities. And dear friends, e-health and telemedicine, although are utilized very commonly in Sino, but there is a difference between both of them. Telemedicine consultation is not just a video consultation, it can be an audio consultation where the patient makes a call to the doctor and discusses about his issues. Video consultation, text, whereas photographs and many a time picture also is considered. Synchronous, that means live consultation. Asynchronous, that means investigations are done and uploaded to the observation by the physician, or else invariably the combination of the above will be utilized in telemedicine. Why it is combination? Many a time the patient will call the doctor and fix up the appointment. That means audio is used. Many a time he is given some proforma to enter the data about his name, biometric information. That means he is introducing text. He may upload his identification verification, maybe photo ID. That means he's uploading pictures. And then video consultation is done. The doctor will send the prescription. It can be a PDF format or else it can be in a photograph format. And many a time it is synchronous. And many a time you also do asynchronous. That means invariably the combination is the telemedicine consultation. Now let's enter into the important division we need to understand: privacy versus security versus protection. If you look at the data privacy, it is safeguarding the identity. Data security is safeguarding the data. What do you mean by that? Safeguarding identity. It is individual data, how it is not shared. This includes even data security. Here, in data privacy, how the patient's information is collected, how it is secured, how it is not shared with anyone, control of access, and also it has to be kept confidential, even in between the doctors or else even the healthcare providers. There are various laws with regard to data privacy. And also, the hospitals needs to keep in mind that data privacy, that means individual patient has right to privacy. That means the hospital should have a robust data privacy policy and make sure the data is not accessed by every person in the hospital. Only the requisite people who need to look into the data for the purpose of treatment should be able to have access to the data. Now, the coming to data security. Here, the hospital also should make sure the complete data, it may be EHR data, billing data, patient's complete set of data should be kept highly secured. Make sure nobody hacks into the data. Hence, data encryption should be there, and also auditing of the data should be done. Further, enforcement and implementation of security, such as firewalls, antivirus, unauthorized access should be limited. And many a time, you need to keep a clean watch and also closed watch about the hackers, how your network can be compromised. Hence, data monitoring should be done and security watch should be done. If you look at in a simple diagram, the data privacy is basically of the individual, data security is the complete data of the hospital, data privacy about the patient, data security is about the whole hospital. Both will be considered as data protection. That, my dear friends, although all these privacy security protection appears to be similar in nature, but however, for the purpose of the legislation, one need to understand privacy, security, and protection changes. Further, we also need to know about data residency, localization, and sovereignty. What do you mean by data residency? It refers to the physical location where the data is stored. It refers to the server's location and other infrastructure used to store and process the data. Where the data localized, that is data residency. What is data localization? It refers to the practice of storing and processing of data within a specific geographical location. Example I will give you. Data residency means the data is kept in Hyderabad. Localization can be considered as the data which is taken within India should be kept within the India and the processing to be done in India. That is, data localization also means processing within India. What is data sovereignty? It refers to the legal authority of a government or other entity to exercise control over the data within its border. So, my dear friends, again, this residency, localization, and sovereignty appears to be similar in nature, but they differ. Residency means where the server is located. Localization is where the data is kept and processed and utilized. Sovereignty is who is having control over this data, whether it is the state or their citizens. Now, if you look at the stakeholders in this Data Protection Act, there are data principals. That means the person from whom the data originates, what are their rights and obligations. Data fiduciaries, that is the person who collects the data. At the same time, he may himself do the processing or he may give the subcontract to somebody else, the data processor. That means data fiduciaries have their certain responsibilities. Data protection officer, data auditor, these are the people who will work to make sure that the data is secured and audited. Data protection board is the board which is an authority to control with regard to disputes, how the redressal mechanism is done if there is any data breach occurs. All these concepts were discussed in the past 3 decades, and various principles have been put forward. These principles are considered as General Data Protection Regulations in the European Union 2018. It focuses on 7 important principles, and these principles will apply whenever you collect the data, store the data, share it, and also process it. The first important principle is lawfulness, fairness, and transparency. That means when you collect the data, it should be lawful, it should be fair, and transparent why you are collecting the data. You need to take consent. The second one is purpose limitation. You need to collect the data once which is required only. You do not collect the data everything you want. It should be limited for the specific purpose. Data minimization. That means you will not be collecting everything under the sun for the purpose of later utilization. You need to minimize the data for the objective question which you have raised or the service you are providing. Hence, you need to minimize the data what you're collecting. Accuracy. The data collected should be accurate. You're not going to meddle. Also, you will make sure that the data provided by the data principle is accurate. Storage limitation. You need to keep the data till the time what is required, or else the person withdraws the consent, whichever is earlier. If the purpose of the data is done, you need to delete or erase it. Integrity and confidentiality. That means whoever collects the data, will process the data, should have high integrity and confidentiality with regard to data. They should not allow any other person to utilize this data. And finally, the accountability. If something goes wrong, Mr. X or Mr. Y, who is accountable, should be held accountable for the data breach. So these are the simple 7 principles which needs to be adhered when you're drafting the law. Let's understand how this DPDP Act of India adheres to this principle and how this legislation evolved. So, if you look at the evolution of the law with regard to digital data protection, the first legislation was Information Technology Act 2000. Over a period of time, the Ministry of Health and Family Welfare discussed about NEHA, that is National Health Authority, so that we can think of securing the health related data of our citizen. Later, the Ministry of Health and Family Welfare also introduced Disha Act, that is Digital Information Security in Healthcare Act. So this invariably discussed about how the data of our patients are secured. It was almost similar to HIPAA, but there are some important differences were also there. All these were proposed by Ministry of Health and Family Welfare. Later, there are very other important things do occurred. Let's look into this. What are the other things happened? Later in 2016 and 17, Ministry of Electronics and Information Technology came into picture. They wanted to secure the data. Under this, the chairman of Justice S.B. Krishna was formed, and Mr. Sri Krishna looked into the matter, and at the same time there was a case in the Supreme Court with regard to privacy. That was the case of retired Justice K.S. Puttaswamy versus Union of India. Let's discuss about this important legislation and later how this Supreme Court judgment played an important way with regard to Justice Sri Krishna committees, the legislation which they drafted. So, discussing about Justice K.S. Puttaswamy versus Union of India, this is an important landmark judgment given by the Supreme Court. This case is considered as the cornerstone to the right to privacy jurisprudence in India. The retired Justice K.S. Puttaswamy raised an important question whether the right to privacy was a fundamental right, which was raised in 2015 in an argument concerning the legal validity of Aadhaar database, whether this the data which is taken by the government and utilized for various purpose. Hence, it was challenged in the Supreme Court for the constitutional validity of Aadhaar and various welfare schemes. The Aadhaar project was linked with several welfare schemes with a view to streamlining the services delivered by the government and also to remove the false beneficiaries. Over the time, various other petitioners challenged the various aspects of Aadhaar in various high courts and also in the Supreme Court. Aadhaar card was demanded by various SIM card. PAN card was linked with Aadhaar card. If you want to open the bank account, Aadhaar card was must. Property registration. Even in criminal cases, the investigating agency started demanding the utilization of Aadhaar database for the pension purpose, for scholarship. If you want to check into the hotel, Aadhaar card is required. For even you want to get the passport, joining the school or college, if you want a LPG gas cylinder, ration card, train tickets, online apps, many entities started demanding the Aadhaar card. That means, is it necessary to provide services to prove your identity? That was challenged in the Supreme Court with regard to various aspects. The Supreme Court took it very seriously because every person, if their data is taken and it is available in the market, it will be a disaster for the country. Hence, the 9-judge bench of the Supreme Court unanimously reaffirmed the right to privacy as a fundamental right under the Constitution of India. At the same time, Apex Court upheld Aadhaar Act as constitutionally valid. Further, the Apex Court said that right to privacy is protected as an intrinsic part of right to life and personal liberty under Article 21 of the Constitution, and also as a part of freedom guaranteed by Part 3 of the Constitution. In addition, this case also laid down the need to implement a new law relating to data privacy. And the Supreme Court ordered the central government to come up with an important legislation how to protect the data of the citizen. Hence, my dear friends, Justice K.S. Puttaswamy case is a landmark judgment with regard to right to privacy not only in the physical form but also in the virtual world. Nobody can invade into your privacy. To recapitulating how it evolved, the first was the Justice Sri Krishna Committee, which looked into the data protection issues. Later, the Justice Puttaswamy's case. Once the Sri Krishna Committee tabled the first draft, which was referred to Joint Parliamentary Committee, which looked into various aspects, did give recommendation, and finally, the Ministry, which is Electronic and Information Technologies, drafted the bill. Many a time was tabled, taken back, debated. Wide consultation was done within India, and various important experts from European countries, Australia, and various other countries where this legislation is there were called for debate. And finally, my dear friends, 11th August 2023, the DPDP Act 2023 was passed. So now let's discuss about the Digital Personal Data Protection Act 2023. This, as I mentioned, was passed on 11th August 2023. This legislation has 9 chapters, 44 sections, and 1 schedule. This schedule talks about the penalty if there is a breach of data. The first four chapters are substantial with regard to how the data is protected and the privacy is considered. The remaining chapters is the procedures, what are the statutory bodies formed, what are the penalties are discussed here. Why this law came into picture? The preamble of this legislation is very clear. It clearly says right of an individual to protect their personal data and at the same time the need to process such personal data for lawful purposes. What does it mean? This preamble is very clear. It has two important objectives. That means it clearly says that every citizen of the India has right to privacy with regard to personal data. But at the same time, the personal data also need to be processed for lawful purposes. What does this mean by lawful purposes? Example, if a child is born, that means the child's birth certificate, Aadhaar, at the same time, if they are providing certain services, it may be mother and child welfare schemes, perinatal schemes in the hospitals. If there is a scheme for a female child, if it is born, a insurance is given to the female child. That means those lawful purposes, the data needs to be kept. Not only that, if the child takes the exam, passes certain exams, those data needs to be kept and verified. If there is any requirement, if the same child becomes adult and wants to buy certain things, property, those property needs to be kept in a digital format for verification and so that nobody tampers with it. Hence, the lawfulness of this data becomes crucial. Now let's look into the various definitions. There is something called as consent manager. This means a person who is registered with the board, which is under this legislation, who acts as a single point of contact to enable data principle to give, manage, review, withdraw consent through accessible, transparent, and interoperable platform. What do you mean by consent manager? In simple words, if the data belongs to you, tomorrow you can nominate somebody to be a consent manager. He can be or he or she can be your parents, your spouse, your friend, or maybe even a legal guardian who will act on your behalf. By chance, if you die, the consent manager will decide how the data has to be dealt. One more example I will give you. Suppose if you are having a Facebook account and there are many followers and it is generating certain income, you can nominate your family members or anybody as a consent manager in your absence, or if you demise, that consent manager will deal and also decide how the data will be dealt. In this whole legislation, the data is deferred as she here. That means in relation to the individual, individual means in this legislation will be referred to as she, irrespective of the gender. Now let's understand what is data. Data means representation of information, facts, concepts, opinion, or instructions in a manner suitable for communication, interpretation, or processing by human beings or by a automated means. What do you mean by automated means? Artificial intelligence also comes into picture. Digital personal data means the personal data in a digital form. Personal data means a data about an individual who is identified by or by in relation to such data. What is data principle? Means you and me, that the individual whom the personal data belongs. It includes children and disabled, but however, special provisions have been made for their protection. Who is data fiduciary? Data fiduciary means any person who is in alone or in conjunction with other person determines the purpose and means of processing the personal data. For example, hospital will take your data for the treatment purpose. They become the data fiduciary. If they give this data for certain other individuals under a valid contract for processing the data, they will become data processor. But the data fiduciary are those people who collect the data. Data processor means any person who process the personal data on behalf of data fiduciary. They are data processors. Data protection officer means an individual appointed by the significant data fiduciaries. Data office means an office that adopts an online mechanism wherein the proceedings from receipt of intimation or complaint or reference or direction or an appeal, as the case may be, to the disposable thereof or conducted in online or in a digital mode. What do you mean by processing? In relation to personal data means the data can be wholly or partly automated operation or a set of operation performed on digital personal data and includes operations such as collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment, or combination, indexing, sharing, disclosure by transmission, dissemination, or otherwise making available, restriction, erasure, or destruction. Processing does not just means analyzing, even includes sharing is considered as processing, my dear friends. Now, another important definition is what is personal data breach? This means unauthorized processing of personal data or accidental disclosure, accidental acquisition, sharing, use, alteration, destruction, or loss of access to personal data that comprises of confidentiality, integrity, or availability of personal data. That means its breach does not mean it's only hacking. Accidental disclosure, unauthorized access, destroying, tampering, all this becomes personal data breach. Specified purposes means the purpose mentioned in the notice given to the data principal by the data fiduciary, why this data is collected and how it is collected and how it will be maintained and removed. Now the section 3 talks about where does this legislation applies. This legislation applies within the country and also outside the country. That means a digital personal data within the territory of India where the data is in the digital format, or else the data which is in the physical format is entered into the digital format. That means imagine if there is a data which is collected on paper and later it is converted into digital. That is within the territory of India. Suppose somebody is selling goods and services, like suppose somebody is selling mobile phone, the brand which belongs to foreign country, maybe US or maybe Germany or maybe any other country, and they are collecting the data which belongs to citizen of India, though it is collected by the foreign entities, they also, those data belongs to the country, that is India. So all these data, that means this legislation goes beyond the border of India, where it is not applicable. This legislation is not applicable when you are storing your own data for processing of your own data. That is not applicable. If your personal data, if you're disclosing in the social media by your own means, that is also not applicable. By any chance, any person who is under the obligation of the legislation for the time being in force in India is making your data publicly available. For example, if you are a judge or maybe a magistrate in the court, as per the law, the magistrate or the judge needs to disclose their assets and it should be available in the public form. The person who is making it available and who has a responsibility to do it, in that such a situation, this law is not applicable. That means by the virtue of a legislation and is doing it, then this law will be not applicable. What do you mean by processing of data? The section 4 is very clear. A person may process the personal data of a data principal only in accordance with the legislation and it should be lawful purposes. Here, The data principal should have given the consent. That means data principal is you and me, from whom the data is collected. You need to give consent for the processing purpose, or else it has to be for the legitimate use. That means it should be under the legislation, or else legitimately used for certain purposes. But however, before collecting such data or processing the data, the notice should be given to the data principal with regard to purpose, storage, and redressal. What about the data which belongs to children and disabled persons? For example, persons with disability. The best example, a person who is maybe blind, or a person with mental illness, or a person who has mental retardation or intellectual disability, which is the word used nowadays. If the data is collected from them, from whom the consent should be taken. Here, the consent should be taken before taking the consent from the child or the disabled. It should be the parent of the children, or else the lawful guardian of the person with disability. That means they have to be very clear from whom the consent has to be taken. And this legislation is very clear about this. Further, it also casts an obligation on the data fiduciary that they will not undertake any processing of a personal data which is detrimental effect on the children and also on the persons with disability. That means there is a huge obligation has been casted upon. That means, my dear friends, if you are dealing with the data of the children and persons with disability, that means you have to be very, very careful. Now let's understand about the consent for processing the data. Two, the consent when you're taking, it has to be from the data principal, or else if they are children or disabled, it has to be from the parents, or it may be the legal guardian. At the same time, consent taken by infringement of any provision of this act or any law being there, that means that consent becomes invalid. For example, if a mobile phone company says that I would like to take the data of yours, and and you're giving a consent to show all your pictures and bank accounts to everyone, and you have said yes to that. And that means this data, which you are going to violate the privacy of an individual, will not hold good here. That means you have to be very careful. You have to make sure that you're not going to violate any law. Either it may be IT Act, or it can be Mental Health Care Act, or it can be POXO Act, where you are not supposed to show the picture or the identity of the children. Even the parent says, yes, I'm giving consent to show my child's picture, but it's a violation of POXO Act. That means even you have taken the consent, that will not be valid. Further, right to withdraw the consent, right to nominate the consent manager, which I have mentioned, and also every consent manager has to be registered with the data board. Now let's talk about the data processing. As you see here, the data processing can be done based upon the consent of the data principal, or else the data of the children can be processed after the consent from the parents, or else if a person with disability is there, the legal guardian has to give the consent. And again, when you do the processing, it has to be within the framework of the law. You cannot violate the law and take the consent. Next, you can also do the processing of the data in the absence of consent, but it has to be legitimate use. What do you mean by legitimate use? If the data is processed by the state, that is by the government or the government institution for providing services. For example, if the government decides to provide free ration or disability pension, they can process the data who are under the below poverty line or certain income. They will process, and the money will be sent to the individual's bank account. Here, the government will access the database of the citizen. In India, it can be Aadhaar card. And this legitimate use to be also by the virtue of the law. That means there should be a law which clearly says, yes, for certain purposes, the database can be accessed to provide services. Or else, by the court order, if there is a medical emergency, maybe a disaster, in such a scenario, to protect somebody's life, processing of the data will be allowed. And for a treatment and also for employment purposes. Here, you please remember treatment. That means the doctor in the hospital will be processing the data for providing treatment. Under the legitimate use, the processing of the data is allowed here. However, there are certain exemptions also has been placed under this legislation. For example, enforcing the legal rights under the court order. If there is a crime, then the data can be accessed by the investigating agency, or else sending the data across the border. That means the data of the people or the citizens can be sent to other country under the valid contract, and it is allowed here. If there is a company mergers are occurring, in such a scenario, the company which is taking over would like to access the personal data to know what is the cost, implication, and how much it should pay to that company. Financial information of the defaulters for the purpose of sovereignty, integrity of the country, and the government can exempt certain people, agencies, startups from this legislation. Now, let's make it very clear under Section 7. Legitimacy or legitimate purposes where the data fiduciaries are given certain exemption. Certain legitimate uses with the consent of the data principle, or else by the government or by the government institutions to provide subsidies, benefits, services, certificates, license, or the permit. In such a scenario, the data can be processed. For the performance by the state or any of its instrumentalities, that means the institution, for any function under any law for the time being, in the interest of the sovereignty, integrity of India, the data can be processed. For fulfilling an obligation under any law for the time being in force, it may be death and birth and death legislation act, where the healthcare provider becomes under the obligation, they have to process the data. Or else for the compliance with any judgment by the court, order issued by the court, for that purpose the data can be processed. For responding in medical emergencies, for providing treatment, the data can be processed. For taking measures whenever there is a disaster to provide health services, for provide certain services to protect the people, for the purpose of employment, the employer can do the data processing. It can be to protect the employer, but however, what is the limit and what is the legitimate use and till what date he will keep the data has to be specified in the rules. At the same time, Section 17 gives certain exemptions to enforce legal rights or claim. The exemptions have been given for the processing personal data by any court order in the interest of prevention, detection, investigation, prosecution of any offense or the contravention of any law. Then the data can be processed. But however, this becomes very, very conflicting. Suppose in a hospital there is a de-addiction treatment or a de-addiction center is there, where the persons who are using drugs are admitted and treated. Suppose the NDPS officer or narcotic and psychotropic control officer would, under this legislation, will come to the hospital and will demand the names of those patients who are undergoing treatment. Under this exemption, he is entitled, and this again can become a double-edged sword where patients will refuse to come to the hospital because under this law they can come and arrest you anytime. Hence, this is a very controversial and it needs to be protected under the rules. If there is merger and amalgamation of companies, there also the data processing can be done. If certain people takes the loan from the bank and they become default, the banks have been given complete right to process the data of that individual, and also central government can give exemption to certain companies. Now the Section 8 talks about obligation of these data fiduciaries. Data fiduciaries are those people who collect the data. They are responsible to follow the act. And also, they will be responsible if the data processor does something wrong. A data fiduciary may engage, appoint, or use any otherwise involve any data processor under a valid contract. That means if the hospital is engaging somebody to process the data or store the data, that means the hospital should have a valid contract. And if you are a doctor individually taking care of the hospital, you need to have a valid contract with all these data processor, where you're going to store the data, who are going to enter the data, and they should actually follow this law. And further, reasonable security safeguard is the word used to prevent the data breach here. The data fiduciary, if there is by any chance, if there is a breach, they need to inform the board and also all the person whose data has been affected. They have to inform. Who is the data fiduciary? It is the hospital or the doctor or the healthcare service provider. If the consent is withdrawn, the data has to be removed, or else, if the person does not withdraw the consent, if the purpose of the data is done, you need to erase the data. Now the question comes is that certain obligations has been casted upon the significant data fiduciaries. Who are the data fiduciaries? Invariably the hospitals with large amount of data who are collecting the sensitive data based upon the volume and sensitivity. If there is a risk involved with regard to data principle, with regard to sensitive data, if there is a potential impact on the sovereignty and integrity of the country, if there is a risk to the electoral democracy, security of the state, and public order, in such a scenario, those people will be considered as significant data fiduciaries. By my own interpretation, the hospitals will be considered as a significant data fiduciaries, and they need to abide by important clauses. That means they need to appoint a data protection officer who will be responsible to maintain the data and readdress if there is any complaint. Further, this legislation also talks about data auditor who will be doing the periodic data monitoring and auditing whether the data is secured and access to control is monitored or not. Now coming to the section 11 to 14, which talks about rights of the data principle. Every data principle, that means you and me, have a right to know the summary of the personal data connected and how it is stored. Right to know the identity of the data processor. If I have given the data to the hospital, I also should know where this data is shared with, who are the data processors. Data principal shall have the right to nominate a consent manager in case of disability or incapacity or death. Right to grievance readdressal if the data breach occurs or the data fiduciary does not listen to a person. Every data principal has a right to correction, completion, updating, and erasure of the personal data. The data fiduciary shall erase her personal data unless the retention of the same is necessary, specified under the law. That means, imagine if the patient has given consent to get the data, and by chance, after some time, he comes and says, please remove my data. Imagine a lady who is around 20 years old has done medical termination of pregnancy. After a few days, she realizes this data is very sensitive and I need to erase this data. And she comes to the hospital and says, please remove the data about my medical termination. This cannot be done because the MTP Act clearly says need to store those data for a certain period of time. Even the patient gives that. Under this legislation of MTP Act, it cannot be removed. Hence, my dear friends, although there are rights of the data principle, and though those rights cannot be violated if there is another legislation which prevents for erasure or withdrawal or manipulation of the data. At the same time, section 15 talks about the responsibility or the duties of the data principle. They need to comply with all the laws which are available. They cannot impersonate somebody else. They cannot suppress certain material information. They cannot register false and frivolous complaint against the fiduciaries. And they need to furnish only such information which is verifiable, authentic, and while exercising the right mentioned above. That is the responsibility of the data principle. But at the same time, Section 16 talks about special provision. The central government, by notification, can restrict certain countries getting those data. But how it will be done is not mentioned. The rules can be explicit here, because if the country like India does not restrict certain countries, like suppose if the central government does not notify, the Pakistan will not get access, or the China will not get access to our data. And if it does not makes the notification, that means they have the right to take the data. That means they can take the data. If they exempts, suppose if the clearly central government says so and so country will not have access to our data, and we allow certain company like Germany or some other country, or maybe even Russia, to access, and by chance if they leak the information to other countries, what will happen? This is the biggest drawback of this legislation. Nothing contained in this act shall restrict the applicability of any law for the time being in force in India that provides higher security or degree of protection or restriction or transfer of personal data by the data fiduciary. That means here there has been reasonable degree of freedom given to the data fiduciary and also to the people who are data processing. Why is this? In a simple reason. If you increase the regulation, increase the legality, the innovation does not occur. What does it mean? Imagine we have Transplantation of Human Organ Act, which clearly prohibits commercialization, and it allows only on altruistic basis, and only the family members can give the organs. In such a scenario, you have completely controlled the organ transplantation. That means because of this law, we require at least 5 lakh people who requires organs, but because of this law, only 15,000 people can get get the organs. That means by regulating highly, you're killing people. Similarly, if you take the important legislation which came with regard to reproduction, that is Artificial Reproduction Technology Act and also the Surrogacy Act, which has regulated completely without allowing any kind of innovation. That means these areas will be killed. Similarly, under this legislation, the government has to balance between the privacy and innovation. That they have beautifully played a role. They were allowed for innovation, allowing other countries to participate in data processing or maybe in artificial intelligence development, and then build a robust mechanism for the purpose. One more example I would like to give here. We have regulated and killed the innovation with regard to development of drugs or maybe clinical drug trial. As a country like India, we have not contributed many drugs to the world, but we are utilizing those molecules which are developed, innovated in the other country. By bringing such a legislation, if you are going to kill the innovation, it is useless. For example, you are a parent. You are making rules to your children and telling what to do and what not to do every minute. What will happen to the creativity and innovation of your children? That's very important point has to be understood when you are discussing this legislation. It is the trade between the privacy versus innovation. In this regard, this legislation also talks about Data Protection Board, which will be formed by the central government, and it has been given certain powers and function to this board. And this board will be given the power of civil court under the Code of Civil Procedure 1908, and it also takes the complaint. It also adjudicates the case. It also can refer for alternate dispute resolution. And if any person is aggrieved by the decision of the board, can appeal before the appellate tribunal under the TRIA. Now, suppose this legislation is there. Should they follow IT Act? Should they follow MTP Act or any other laws at this point of time? This law is very clear. This law is an addition to other laws. That means you cannot say I'll be following Data Protection Act and I will not follow MTP Act or TOHA Act or Transplantation Human Organ Act. No. The provision of this act shall be in addition and not in derogation of any other law at the time being in force. That means you need to follow this law and you also need to follow all other health legislation. It can be National Medical Commission Act, it can be national medical regulations, maintaining the data records, health records, maintaining health records under the Medical Termination of Pregnancy Act, maintaining the data under the Surrogacy Act. All those legislation need to be followed along with this legislation. For example, if there is an event where there is a conflict between the provision of the health legislation and this DPDP Act, in such a scenario, then with regard to that conflict only, this DPDP Act prevails over that legislation for the point of contention only. That means every hospitals and the doctor need to follow Information Technology Act. They also need to follow the Information Technology Rules 2011, that is reasonable security practices and procedures and for sensitive personal data information, Electronic Health Record Standards of India 2016, telemedicine guideline needs to be followed, NNC Act should be followed. Further, every hospital, when they are keeping this data, also need to follow all other legislation. It can be PNDT Act, it can be Mental Health Care Act of 2017, it can be Right to Persons with Disability Act, or even Indian Penal Code, which is BNS now, has to be followed. That means this legislation is a supplementary and addition to other legislation. What are the penalties for violating? Under this schedule, the penalties are very severe. If there is a breach in observing the obligation of the data fiduciary to take reasonable security measure, the punishment or the penalty will be 250 crore. That means if you're a hospital and you're collecting the data and you do not maintain reasonable degree of security safeguards, be ready to shell out 250 crore to the Data Protection Board. If there is a breach in observing the obligation to give the board and also the data principal about the breach, if you don't inform the board and also the patients that the breach has occurred again, 200 crore penalty can be given to the hospitals. With regard to breach in observation of additional obligation in relation to children, under Section 9, if you don't keep the data secured with regard to children, 200 crore rupees penalty can be given. Breach in observance of additional obligation given to state's data, significant data fiduciary, that means hospital, 150 crore can be given. That means if you don't nominate the data protection officer, if you don't have a data auditor, be ready to pay 150 crore. If the data principal, that the patients, if they give false information, they can be charged with 10,000 rupees by the data board. Breach of any terms of voluntary undertaking, that means if a person undertakes voluntary, like it may be a consent manager, then there are penalties which have been given here. Any other breach under this legislation will lead to 50 crore rupees penalty. Now let's discuss about the impact of this legislation on the healthcare industry. All the doctors, all the hospitals, or the group of doctors who are running the hospital, collecting the data, need to encrypt the data. They need to keep reasonable security guards. What are those reasonable safety guards? They need to have the network which is having a firewall, which has antivirus. There should be a consent manager. They should have a data protection officer, data auditor who will be monitoring the data. Access and control to the data is clearly maintained and monitored, and the security certificates are given, which will be mentioned in the rules, and that need to be followed. And again, encryption technologies protecting the data during transmission and storage so that they reduce the risk of interception and data breaches. That means You need to encrypt the data not only while storing, but also when you're transmitting the data for insurance purposes. You need to be very clear who will get access to this data, whether the doctor can access the data, whether he can retrospectively monitor, modify, or only prospectively he can monitor and modify, whether the nurses can only see the data, how much the data they can enter. Vendor security, that means security measure also to be will be held responsible for the data fiduciary, that is hospital and doctors. One of the data vendor, that is a person who is keeping the data in the cloud, should also will be abide by the law, and if there is any breach, the data fiduciary will be held responsible for those data processor if they are irresponsible. If you have hired electronic health record, cloud or third party vendors or softwares, or if you are using artificial intelligence, or you are using an hardware which is collecting the data, please make sure you have a valid contract, and that contract clearly says all these third parties will abide by the legislation in India, all the laws and regulation in India, not only prospectively, any new legislation which comes into picture, they will be held responsible for data breach which occurs at their end. And they will take the full responsibility and pay the amount if there is a breach on their end for the data protection board. That means the valid contract should clearly mention about the liability, responsibility, and how much they will pay if there is a breach. All the hospitals should hire the data protection officer and also have a mechanism and system in place. If there is any data breach occurs, immediately inform the data protection board and also the data principal about the breach. Regular audit and monitoring by the data auditor is very essential. At the same time, the hospital should not overshoot the consent. That means the hospital should make sure the data minimization is there and data purpose limitation is there. That means they have to take the only data which is required for treatment purposes, should not store the data beyond the time it is required. Like suppose NMC Act very clearly says that by the last day of the contact with the patient, after 2 years, the data should be removed. That means you have to remove the data. For example, if a telemedicine application is collecting the data, and when they're collecting the data, if they ask permission to contact list of the person or the patient, it is not allowed. That means you need to collect only the consent with regard to provision of services. Unauthorized access to the phone content of the patient will not be allowed. And you need to use the data legitimately. That means all the hospital should make sure anonymization, de-identification of the data should be done. If a pregnant woman is taking treatment and availing the prenatal services or perinatal services, antenatal services in the government institutions, the information can be shared with the others as per the law, but you need to maintain the anonymization. Only the number of people who are availing the services can be given, not the individual data. Be prepared. Need to have a comprehensive plan. If there is a data breach occurs, who are the people who are going to inform under the this legislation? You need to do data privacy checks, monitor data auditing, and also employee training with regard to DPDP Act and how you need to maintain the security and privacy should be done. Now let's critique about this legislation. There are very important positive aspects of this legislation. This legislation upholds the privacy, which is enshrined now under the Supreme Court decision under the Constitution of India. Consent of the data principle is very essential before you process the data. Special protection has been given to children and persons with disability. Penalty clause has been very clearly mentioned, and it is welcoming. If the data principles gives false information or impersonate, 10,000 rupees punishment has been given. And this legislation also talks about alternate dispute resolution, which is very well welcoming. At the same time, there are negative aspects. Here, the government has been complete power with regard to owner of the data, and the government will not be held responsible if there is any breach occurs at the government end. The government has been exempted with regard to punishment, and the cross border transmission of data is not completely banned here. Of course, you can argue whether the innovation is given primary over the privacy. Invariably, the innovation at this point of time takes precedence. Whether it is right or wrong, over a period of time, we will come to know. And the Data Protection Board is not completely been told in the legislation and in the rules. It should not become completely bureaucratic. The people from the corporate world, the people from the civil society, and various startup people, the hospital, the people representing the various other sectors who are processing the data should be brought in under the rules and security measures to be taken. There are various conflicts with DPDP Act, RTI Act, various others legislation. They have not been cleared. That means in the near future, there are many cases which may end up in Data Protection Board. Finally, the purpose of Data Protection Act is to empower the citizen. But if the citizen gives false information, they can be punished under the legislation by 10,000 rupees. Whether it is right or wrong, you have to decide. To conclude, my dear friends, digital intervention is going to be here. At the same time, it is evolving rapidly. We need to engage the industry. We need to innovate. At the same time, we need to protect the privacy of the citizen. It is very difficult. Imagine if you want to live in this world and you do not want to use the internet. Is it possible? You may say, I am very concerned about my privacy. In this world, especially in the data world, is it possible to be private? It's a big question. And further, there are digital interventions like AI. They have their own biases, racial discrimination, geographical discrimination, religious discrimination that have not been addressed in this legislation. Further, unconditional acceptance, services on demand at the comfort of home will be the future. In such a scenario, you need to share your personal data. That can be only possible for innovation when this legislation is slightly liberalized. However, when this legislation is implemented and there is any conflict, all these 7 important data principles should be followed. If you don't follow this principle, then the disaster is going to strike. To summarize, my dear friends, this law is applicable within the country and across the country. That means whoever is going to provide data, who is going to provide services, who are selling devices, that the law will be applicable. Data principles have been given important rights and obligations. At the same time, data fiduciaries have been given certain responsibilities. At the same time, the government has kept lawful or legitimate use of the data has been given permission. But however, the government takes the complete power with regard to this legislation and exemption from any kind of scrutiny or else punishment. Although this legislation is balanced between innovation and privacy, over a period of time, this law be will be knowing whether is helpful or dangerous. And anyhow, the law is dynamic in nature. As and when required, the law will be amended. Thank you very much for giving your valuable time. Stay safe.